Hey everyone, welcome to my Module 13 presentation about tort liability. So first, to define tort liability, this is when there's a civil wrong for which a remedy must be obtained to make the situation better. Usually this would be in the form of financial damages. Two types of tort liability. There are intentional torts and negligence. So with intentional torts, there are four different kinds of intentional tort. The first would be assault, which doesn't automatically have to come along with a physical act. It could be placing somebody in fear of a reasonable amount of danger. Battery is actually carrying out that physical aggression. False imprisonment. This would be when students are illegally restrained or detained in some way. And defamation, of course, is attacks on intentional attacks on a student or somebody's character. For negligence to be proven, these four questions have to be asked. So first, does the person have a duty to uphold? The second would be, was there a breach of duty? Was there a failure to adhere to reasonable responsibilities? And then the third question is, are those two things connected? Proximate cause. So was it the breach of duty that caused whatever to happen? And then lastly, there has to be an injury, physical or mental injury of some kind for negligence to be true. So the first case that I analyzed was a pretty sad one, really sad one. Pierce versus the Hearn Independent School District. So in this case, a student in Texas was in an agriculture program, and that teacher asked him to take the ATV to go to a neighboring farm. I should add that like training and responsible handling and how to drive an ATV, this wasn't a part of the curriculum. So teacher asked the student to go get some tools or bring some tools to a neighboring farm. Unfortunately, the student with another passenger got in an accident on the way back, and that student actually passed away. So the parents sued, claiming deliberate indifference, and the courts actually did acknowledge that there was some wrongdoing here by the teacher, but did not hold them accountable because they didn't think that the teacher, through their actions, should have had a reasonable expectation that loss of life or an injury of that matter could have stemmed from their request, from their action. So in my district, even though the courts ruled in that way, I really think that our school leaders would handle it differently, or not differently, but regardless of the court outcome, I think this teacher would be disciplined, likely terminated. There was some pretty poor judgment. So some proactive measures that should have happened in this case, and that would, in our district, would be there'd be safety, well documented safety measures, protocols that families would sign, just like a syllabus. The expectations of what students would be doing, what types of vehicles they would be driving, if that was the case, or tools they would be using. This would all be clearly communicated to parents. And as far as ethics, it's ethic number one, working in schools, it's our job to keep kids safe, and that's the first priority. In this case, it seems like the teacher was kind of prioritizing completion of a task and getting some work done, and got lost in, overwhelmed with how much there was to do and to finish a project, and lost sight of, ethic number one and keeping kids safe. The second court case I looked at it's not New Mexico. There's initials NM versus the Anchorage School District. In this one, a kindergarten student was at dismissal time excited to bring mom some materials or something that he had made for her during the day, and while running there fell and had some really significant injuries to his eyes and his face. So the family sued for negligence, claiming that there were shrubs that the student fell on that should not have been there, since it was such a heavily trafficked area. And they actually won this and ended up settling for $4.5 million. So for us, our reactive measures that I think our PR department would be heavily involved in this case, just to send condolences and show empathy for the family and the student. But I don't know. I feel like there's also, in our litigious society, we're always at risk. And I'll even add a lawsuit later here where I was a part of. I think you could be well-intentioned and I don't want to say do no wrong, but very easily miss something such as cleaning these shrubs that leads to a tragedy. But I don't think our district would react too aggressively toward our personnel. But a proactive measure that does need to take place is we really need to develop a proactive maintenance and operations plan. With Dr. Reed, actually had a class not too long ago, district facilities, and learned a lot about this and saw that really is an area that our district's lacking. And in this case, I think that would be beneficial if this existed beforehand. Professional ethics. In this case, I'm not sure that there were ethics or expectations or values that were violated. I guess I didn't see a picture of where the student fell, but from the description in the article and the reference at the end, it seemed pretty feasible that there would be some shrubs. And it's just really sad what happened. The next case, this one's actually ongoing right now. I think as I was searching, it was something like 5 hours ago when I made this the other day that this article popped up. But the parents of a student, this to me is just horrific, but parents of a student with autism sent an email to school leaders about bullying, sending pictures of bruises that the kid had suffered at school. Unfortunately for the family, the alleged bully was actually the kid, the son of an administrator at the school, and they didn't investigate. They made it very difficult for police to access information. They just flat out didn't investigate the bullying, said it didn't happen, even went as far as to say what the victim, did to bring things on himself. It's just super sad. I can't even say how our district would react to this because I like to think it would just never happen. We thoroughly look into every instance of bullying, regardless if it's a staff member's kid or not. If anything, I think it's pretty common for our teachers and administrators to hold staff members, students, or children who are students here, even to higher standards. So this just wouldn't happen here. As far as ethics, nepotism, resisting that is an ethical norm, or at least it should be for every person in power. And that was just totally lacking in this case. Man, this one's not fun. Anwar Jackson versus Bridgeport High School et al. I am in the et al. So two students actually claimed in court that I illegally had searched their phones as a part of a recruiting investigation. What really happened is the football coach got fired for recruiting, for violating our MHSAA rules, caused the school itself to be withheld from the playoffs for a couple of years. So the school as a whole was held accountable because his actions were so egregious. He was also being kind of shady with money. So, there were just lots of reasons, let alone the fact that he's an at-will employee. So his contract wasn't renewed 1 year, and he just went all out on attack mode and got some students to join him in a lawsuit that I had something to do with. So what really happened is one kid, I had to interview him about how he ended up enrolling at our school. And as a part of that, the student said, here, look, let me show you some text messages that one of your assistant coaches sent me when I was at a different school. So he showed me those. I didn't ask for them, and that did, end up in a report and was a part of our report to the state and a part of the accountability for the coaches. That later turned into, I made him give me his password, and I demanded that he show me all of his text messages, and these were just all lies. So the, I guess, sad part is that even though the district's attorney said they have no case, obviously, because this just isn't true, they said it's going to be cheaper to settle than for the legal team to actually defend the case. So I don't know. I hope the district I'm in now would actually still defend it. There's reputations at stake, and just you don't want to set the precedent that you can get a couple $1,000s by suing, even if it's based in a lie. So proactive measures, obviously it's always best to have second parties around. With a search, if it was actually a search, I would obviously have another administrator, a colleague in there with me. So I don't know how much more could have changed, because sometimes, a lot of times, just by nature, we're having one-on-one conversations and interactions with students. But this was just a reminder to have a second party around as much as possible. Professional ethics. I think there's a little bit of an ethical dilemma that the school board and the superintendent had. On one hand, I know they wanted to protect me. On the other, they owe it to the community, to the school, to be smart with money. So that was quite an ethical dilemma they had. I guess I don't know what the right answer is, but I would have liked to seen this case not be settled and have the truth come out. Another case that I studied was a teacher responding to a fight and breaking up a fight. So there was a student from an alternative school that actually went to, which was a different campus, went to the traditional high school with the specific intent of engaging in a fight, which they did when they got there. One student was clearly the aggressor. This seemed to be more of an assault than a fight, really. And to protect the kids, try to keep them safe, the teacher restrained the aggressor. The aggressor stopped for a second. Teacher asked, I'm gonna let you go, but I need you to calm down. Person said they would, but then didn't. Started fighting again, to which point the teacher restrained her. And through this fighting back from the student, she actually broke her arm. So there was a lawsuit that the family claimed that there was assault, battery, and negligence on the teacher's part, and they lost that lawsuit. So if this were to happen in my district, I think an additional refresher training might be held regarding, just for all staff. It's good to know how to respond. We don't have a lot of fights, thankfully, but just disturbances, or if there is some violence in the hall, like coaching teachers and staff how to respond to that. A proactive measure that we do here now is we have staff trained in CPI. So Crisis Prevention Institute, all administrators, special educators, I think our parapros, and definitely our security team are all CPI trained. So perhaps if this happened, maybe we would look into enhancing how many people, maybe somebody in every hall needs to be CPI trained, for example. Professional ethics, this goes back to the first case that I talked about. We have a responsibility, and every decision we make should first start with safety. I don't think there was any ethical violation here, because the teacher was just doing their best to stop an injury. And the injury that did happen ended up being self-inflicted. There are my references. Move myself out of the way so in case you want to see them all. And thank you for listening.